Good morning and good afternoon. My name is Kathleen Regan, and I'd like to welcome you all to a LexisNexis complimentary CLE-eligible webinar titled Up in Smoke, the Drug Law Evolution and the Workplace, Managing New Risks. Before introducing our speakers, we have a few announcements. If you have access to live streaming today, we would encourage you to use that method to participate in today's webinar. Please take note of the survey that is available to you. We ask that you please complete it, as it gives us excellent feedback so we can continue to bring you outstanding programs that meet your needs. Our panelists today welcome your questions. You can submit those questions using the Q&A section of the platform throughout our program. The panelists will try to address as many audience questions as possible. Please keep in mind all questions may not be answered due to time constraints. No questions will be asked verbally, and instead should be submitted using the Q&A section of the platform. And now I'd like to introduce our speakers. Complete biographies are included with today's PowerPoint. Our moderator today is Mark Walls, Vice President of Communications and Strategic Analysis at Safety National. Mark leads all thought leadership activities at Safety National, which provides alternative risk funding for workers' compensation through independent agents and brokers. Charles Oxender is a senior attorney at Miller Canfield and specializes in traditional labor law, collective bargaining, grievance, and arbitration processing. Albert Rander Jr. is a principal at Franklin and Prokopic and concentrates his practice in the defense of employers in labor and employment, workers' compensation, tort liability, administrative and regulatory matters, and general civil litigation.
And now I'd like to turn the program over to the speakers. Mark, the floor is yours.
Thank you so much for joining us today. In case you're confused on what today's topic is, we've provided a visual aid here in the first slide. Yes, we're going to be talking about pot, dope, Mary Jane, weed. This is an evolving topic that's affecting people on the employment practices side and also on the workers' compensation side. And so we're going to talk about how this is evolving and the things that you need to be concerned with. I wanted to share a little story going into this. I was at the RIMS conference this year, which was the end of April, and for those of you that aren't familiar with RIMS, that is the big risk management educational conference that is held annually. It's the biggest risk management conference in North America, and it was held in Denver this year. And let me tell you, that was an eye-opener for the attendees. If you're wondering what the world looks like in a state where recreational use of marijuana is legal, go to downtown Denver and walk around. It was everywhere. Yeah, everyone that was attending the conference was amazed by the fact that everywhere you went, you smelled it, you heard it. It was the shops were everywhere. So that's a good taste of where this is going. So let's start with.
Sounds like the fifth floor of my law firm.
Yeah. Let's start with how did we get here? Way back in 1970, legislation was passed to set up the Controlled Substance Act to really regulate the manufacture, importation, possession, use, and distribution of certain substances. They created schedules of drugs with defined qualifications, and this was maintained by the FDA and the DEA. That schedule is subject to change through legislative amendments and petitioning. In addition, as we've seen, states can maintain a separate classification list that conflicts with the federal classifications. Marijuana is currently scheduled as a Schedule I drug under the Federal Controlled Substances Act. What does that mean? Well, that means it's one of those bad drugs that the federal government feels that there is no medical use for. So it may not be prescribed, administered, or dispensed under federal law. So there's a list of some of the other drugs that are bad drugs. Not on that list, but included would be things like methamphetamine. So this classification has been in place for years and years and years and years and years. And as we have seen, states have made changes to their own classifications where they have changed the ranking of marijuana. The first state to legalize medical marijuana was, get ready, shocker, California in 1996. followed closely by Oregon and Washington in 1998. Currently, there are 20 states plus the District of Columbia that have legalized medical marijuana. And this list keeps growing. There are currently 3 states where this legislation is pending, including Florida, which would be the first quote-unquote southern state to allow medical marijuana. And everything I'm hearing is that this will be approved and pass in Florida. There are currently 2 states that allow the recreational use of marijuana. Colorado, which has been full-blown recreational use since back in January, and Washington, which is just getting rolling with it right now. Now, I will say that it is, if you have been to some of the states that have had medical marijuana in place for a very long time, for example, San Francisco, California, or Portland, Oregon, you realize that it's a very short trip from medical use of marijuana to recreational use of marijuana. Either that or just coincidentally, there's just an awful lot of people walking around those towns that have those medical marijuana cards. So, to think that this isn't coming to a town near you soon, oh, it's coming, so we need to get ready for it. All right, Bert, at this point I'm going to hand off to you to talk about medical marijuana in the workplace.
Sure, and let's just start off to see how we actually got here. When we look at recent national statistics of drug and alcohol impairment in the workforce, we've got a recent study that shows about 8.5% of full-time employees in the U.S. have reported using illicit drugs. You've got about 8.8% that have reported heavy alcohol use, and this is all self-reported. So as physicians will often tell you, the self-reporting statistics are a little bit usually on the low side. You've got another 3.1% that have admitted to using drugs before or during work hours in the previous years, and 2.9% admitting to working under the influence of an illicit drug. Interestingly, you've got 3.1% using drugs and only 2.9% saying they've been influenced. So I guess that 0.2% are those that perhaps smoked but didn't inhale. Obviously, you've got the workplace concerns. When somebody is showing up to work under the impairment, whether it's medical marijuana or a host of other narcotics, alcohol, whatever it might be, you've got to look at the impacts on the employees. And you've got issues of increased rates of absences, tardiness. You've got the safety risks, which include an increased risk of injury to that individual, but not only to that individual, to coworkers, to other vendors, customers perhaps, and you've got significant safety risks along those lines. You've got other issues. You've got morale issues. You've got the employees' decreased ability to self-care. You've oftentimes got family discord and emotional issues. You've got increased risk of comorbidities, depression, mood disorders, and all those types of things that are impacting the employees that are using this before, during, and after work. And those are some of the things that the employment laws and employers are obviously trying to curb against. Now, when you look at the way the states are starting to handle it, of course, we'll be talking a lot during this session about the conflict between federal and state law. In a nutshell, you've got the feds that are saying that it is still illegal as a Schedule I drug, that it's still illegal, and in the same class, as Mark said, with LSD and heroin and what some people might call a Good Friday night. On the other hand, you've got the state laws, which as they're increasingly passing not only the medical marijuana, but also starting to look at the recreational use as well, as a couple of states have already done. So you've got this internal conflict, which is going to really be a lot of our conversation today on this. And the first one is when you really look at the Drug-Free Workplace Act, the DFWA, that was passed, which requires certain federal contractors and all federal grantees to provide a drug-free workplace as a condition of receiving a contract or grant from a federal agency. Now, obviously, if they're receiving this contract or grant from a federal agency, then they've got to maintain this drug-free workplace. Well, what about those states that have imposed medical marijuana laws? Generally speaking, actually almost uniformly, there are going to be exceptions where an employer need not worry about the state law and still must continue to follow federal law. That's generally the case. You know, you can look at a few states that have dealt with this directly. You've got Arizona. Arizona has indicated that you need to have an established impairment. It's not only that a person is perhaps receiving marijuana or has been prescribed marijuana, possesses a medical card. You've got to actually establish that there is an impairment for some of these drug-free workplace issues. You've also got states such as Washington, where Washington has specifically carved out, and this again is the state of Washington, has carved out that employers may establish drug-free work policies and that nothing in the legislation actually requires an accommodation for the medical use of cannabis if an employer has a drug-free workplace. Obviously, that leaves a little bit of wiggle room that if an employer has not established a quote-unquote drug-free workplace, then perhaps they're not going to be able to avail themselves of the protections. But if, in fact, if the employer has a policy in place and has established itself as a drug-free workplace, then Washington's legislation will protect an employer and not require them to allow some sort of accommodation. You've got some states such as Delaware where there are specific requirements within its legislation where that unless there is a reason that the employer can establish due to licensing or losing some sort of monetary benefit under federal law, i.e. the federal contractor issues, an employer in Delaware may not discriminate against a person in the hiring, termination, or any term or condition of employment if the discrimination is based upon the person's status as a cardholder. Generally speaking, though, even under Delaware's law, which does establish this anti-discrimination component, even under Delaware law, if you can establish that the person had used, possessed, or was impaired on the premises, then you're going to be generally fine, and the employer is going to be safe.
This is Chuck. I just jump in real quick. There's a similar prohibition in the Michigan Medical Marijuana Act, where again it states that you can't use any disciplinary action or take make any decisions based on the use or the fact that you have a medical marijuana card by a business or occupation or professional licensing board. So if there's a licensing board that you have to go through, they can't use the fact that you have the medical marijuana card against you in determining whether you are able to get the license or not.
Yeah. You know, one thing, I think this may be a good place to jump in. I see that there's a question, and I think that we'll try to address them as we go along to the best that we can, so long as they're fitting within that slide and not something we'll be addressing later. But one of the questions does involve what exactly is meant by impairment. And I think it really is important that the medical science in medical marijuana really has not caught up to what the law is. You know, unlike alcohol, where it's really easy to determine what a person's blood alcohol level is at the time of a test and then extrapolate the data out to determine what the level of alcohol in the blood was at the time an occurrence occurred. And from that, you could get a pretty good sense of what impairment actually was in terms of visual issue, reaction time, and things along those lines. The problematic thing that we see with marijuana, and whether it's recreational or medical, is the fact that it's really impossible to determine whether or not there is an impairment at any one given time, at least from a testing perspective. Because in the testing perspective, generally speaking, a person can have impairment levels registered in the system of testing for 5 days after use, and even in the chronic users or abusers, even up to 30 days, you can detect the presence of marijuana in the system. But from that, you are completely unable to determine whether or not there is, in fact, any impairment. So when you're looking at a lot of the issues that we'll be discussing going forward, including work-related injuries and such, there becomes a real proof problem from the testing is this person impaired as of the time of the test, or is this just a detectable trace that has been in existence in the person's system for the last 5 to 30 days? One of the other issues that we deal with, and I just talked a little bit about the Drug-Free Workplace Act of 1988, but one of the other big issues is when you look at DOT and other federal licensing and agencies that have their own regulations. And certainly under DOT, anyone that's a motor carrier or has drivers out on the road certainly know all well and good that they don't want impaired drivers behind the wheel. Not only is it a safety issue for that driver and anyone that's with the driver, anyone else out on the roadway. From a company's perspective, you've got tort litigation issues, you've got negligent retention issues, you've got potential negligent hiring issues. There's a whole host of liability, not to mention it simply looks terrible when a motor carrier's name is across the evening news because they've employed somebody that's using marijuana at the time of a horrific accident. So DOT has been pretty clear, and they've issued some guidelines and some fact sheets, and it's pretty well written in terms of a couple of almost double negatives in there, but the gist from the DOT's perspective is just because somebody's been approved or quote-unquote prescribed marijuana under a lawful state system, that's not going to negate the motor carrier's right and actually obligation to keep that person from going out on the road. And DOT has been very clear that you are not going to say that this is a negative test simply because this person is following state law on the use of medical marijuana. So those motor carriers out there with commercial drivers or other folks that are using drivers, at least under DOT guidelines, you are safe, in fact, from a DOT perspective, and you're going to be obligated from the DOT perspective not to put that person out on the road. Now, when you look at other potential issues, when you've got EEOC and issues involving potential claims under the Americans with Disabilities Act, the ADA, you could potentially, as we've seen in other types of disability litigation, you could potentially see a conflict between the EEOC's interpretive guidance and DOT's requirements. But for anyone that's a DOT regulated entity, they're going to side with DOT and they'll probably take the fight. Unfortunately, as one of my partners used to say, sometimes an employer's wakes up in the morning and they've got two options. Do I want to be shot today or do I want to be stabbed today? Because neither one of the two options are going to be all that great. But the motor carriers that I regularly deal with are certainly going to follow DOT's guidance as opposed to the EEOC's. But right now there doesn't seem to be a significant conflict in that regard.
And just to follow up for a second on the issue of proof of whether, how long ago the person consumed the marijuana, it is a very difficult thing to decide. I've had a few cases. I do a lot of union labor work at cases where it looks like somebody's, high or stoned. Maybe the bloodshot eyes are running slow, that kind of thing. And we've had cases where they've even taken them for a drug test, and the drug test comes out positive for marijuana. And then, actually we lost an arbitration case because the arbitrator said we couldn't, with any certainty, pinpoint when the person took drugs. Of course, at the hearing, the person said, I did it Friday night. I haven't done anything since then, and this is Monday morning. So it does present a very difficult burden on employers in that kind of context where you have to try to pinpoint when the person did it. Did they do it that morning? Are they on drugs at the time? A lot of that, we do regular training for supervisors to kind of pinpoint when somebody is acting, their voice is just, their voice isn't right, they're showing signs of being under the influence, that kind of thing. But it's really difficult in that extent to answer that question.
All right, next slide. Go ahead, Bert.
Yeah, I was just going to say, you know, we've just addressed a few of the issues that you're looking at. I mean, the problem is with these laws is like everyone's familiar in the employment arena, the overlapping maze of laws is extremely burdensome to try to navigate through. You know, here we've put only three. You know, we've talked about the DOT issues. We've got the private sector issues for those companies that receive federal contracts, i.e. the Drug-Free Workplace Act of 1988. You've got other types of issues. We've touched briefly on the ADA. We'll talk a little bit more about that. You've got workers' compensation state system issues. You've got the tort liability problems. You've got the negligent hiring and retention issues. OSHA is another interesting one. You've got under the general duty clause, there are no specific standards really at issue that I'm aware of, but under the OSHA issue, you've got that general duty clause to provide a safe work environment. Well, what exactly does that mean in terms of if a person is following doctor's advice or recommendations and or prescription for medical marijuana, even though under federal law they're not supposed to be truly prescribing medical marijuana, what does an employer's obligation to provide a safe workplace mean? If you're allowing folks that have medical marijuana and are using that, do you want them back in the workplace? There is some argument that perhaps this general duty to provide a safe work environment further bolsters an employer's rights to go ahead and terminate individuals that are actually using it. You know, I think generally speaking, employers are going to be reluctant to want to quote-unquote discriminate against people simply because they've been prescribed it or because they hold a medical card. But once they've established actual use and presence in the bloodstream, you know, this general duty clause under OSHA is at least one more support perhaps for employers that want to discipline, including up to and including termination of those employees that have it.
Let's go ahead and jump now to the wrongful termination claims that we're seeing arise out of this. How are the courts dealing with this? What are the trends that we're seeing? Chuck, why don't you take the lead on this?
Sure. We'll go with the Cassius case, since it is out of the Sixth Circuit, out of the Michigan case, actually. And Joe Cassius, actually, when you talk about these cases, especially in terms of the medical marijuana, there's, you know, looking at the people involved, they're quite, and often, in many cases, you feel like kind of sorry for the people that they're in the situation where they're in the treating with the medical marijuana to start with. And Cassius is a good example. Cassius was diagnosed with sinus cancer and an inoperable brain tumor at 17 years old. He started working for Walmart in Benton Harbor, Michigan in November of 2004. The Michigan marijuana, when he was 20 years old, by the way, the Michigan medical marijuana law was passed in 2008. And once it was passed, he went to his doctor. His doctor said, maybe this will help. And so he started taking it. He'd been with Walmart almost 5 years, about 4.5 years, and he twisted his knee, pushing some carts at work. And the next day, he came into work, and his knee was bothering again, so he went to the clinic, and he went to the emergency room, and as part of Walmart policy, they issued him a drug test because he was injured at work. Prior to the drug test, he showed the doctors his medical marijuana card, so I'm on, taking medical marijuana, so it's going to show a positive. A week later, obviously, the test did come positive, and the corporate office at Walmart instructed the store manager to terminate his employment. And he argued a couple different claims, but essentially he argued that, well, I'm a medical marijuana, so you can't discriminate me, and then he also argued a general public policy kind of argument in Michigan, alleging that because the medical marijuana law was passed in Michigan, it evidenced the public policy to allow people that have these medical marijuana cards to use it and not be terminated. And this is one of those examples of the kind of federal-state back and forth that you have, is essentially the courts relied on the fact that it's still illegal in federal law and basically said that Walmart had the right to continue its zero drug policy, tolerance policy. And essentially, they found that the Act didn't regulate the private employer's right to have the zero tolerance policy, and the court also found that there wasn't any, and couldn't make the claim for a public policy because it would essentially erode the at-will employment, the general at-will employment situation for employees in Michigan. The statute in Michigan specifically said that nothing in the Act shall be construed to require an employer to accommodate the ingestion of marijuana in any workplace or any employee working while under the influence. So it's slightly different. It basically says you don't have to allow them to do it, either smoke at work or ingest it at work or be high during work. But it doesn't really get to any issue about what do you do if it's off work. And so that's kind of similar in the vein that we were talking about earlier. Is, this person, Mr. Cassius, essentially said, look, I did it. I do it at night when I get home from work. In the morning, I take different medicine to help, me through the day, and I don't smoke pot before I come to work. I come to work, and then when I get home, I smoke it, and it helps alleviate stuff at night. So that's why it's in my system. I've never showed up for work under the influence. He didn't have anything in his record that would demonstrate that he'd had problems, because of the ingestion of the marijuana, but again, it came down to the fact that the court found that the statute couldn't override Walmart's ability to have the zero tolerance policy. So that case, actually, the quote on the slide right now is that's the district court case. It was appealed, and the decision I just kind of referenced was the Sixth Circuit case that was issued in September of 2012.
Chuck, do you feel the outcome would have been different if Walmart was a public entity employer versus private sector?
I would doubt it in Michigan. I mean, I still don't think, I don't see that it would have much of a difference in Michigan. I don't think that the courts here would tolerate it any differently. I think they would generally find essentially the same. And I just don't see that the courts would like that. I think that, and we'll talk about this a little more. We talked about it a bit when we were starting. Is you see that it's kind of a trend. There's a trend towards kind of this loosening attitude towards marijuana, but I don't think the courts are there yet in Michigan. And I think that based on the kind of the laws, the at-will kind of rules, that it would be. I think the courts would still come out and say the public sector employers have the right to have the zero tolerance policy as well. I haven't seen a case that's even been brought under that. The one thing about Michigan, too, if you look at public employers, is a majority of them are unionized. So almost every public employer I represent, which is, school districts, municipalities, counties, they're almost all unionized workforces, so they didn't have very specific drug policies in the collective bargaining agreements. So that's potentially why there probably hasn't been a public sector case that's even gone through the courts, because most of those are dealt with through the grievance arbitration procedures. And when I was referring earlier, we've had cases where we've had issues where people have been disciplined for drug tests for marijuana that showed use, and then the difficulty is always for the employer to show when they used it and where they actually impaired at work. And we've had cases go both ways. There's a case that was actually a Detroit bus driver in the bus system a few years back. That's probably about 15 years ago or so. But it was a female bus driver who tested positive and essentially said, I was at a party, it was secondhand smoke, I didn't smoke any, but the numbers were really high, and it wasn't all that plausible, but it was actually even secondhand smoke. But the arbitrator said, okay, and bought her excuse, and said essentially he didn't show that she was impaired at work, even though she had been in an accident, and she ended up getting her job back. That was before the medical marijuana statute passed. But you see, again, public sector, especially in Michigan, is most of those cases are going to be governed by a collective bargaining agreement.
And can you clarify what did the Sixth Circuit rule in Cassius?
Sure. They said that the Michigan Medical Marijuana Act didn't impose any restrictions on public or private employers to any restrictions on their zero tolerance policies. So in other words, they still have the right to do that because largely they relied on the fact that marijuana consumption is still prohibited and illegal under federal law, and that the way the statute was passed itself in Michigan, it didn't have any kind of specific impact on private sector or public sector employees, for that matter. During the home proposal period, because in Michigan the act was actually it was a ballot initiative. So it was a group that supported it, and I think it's the same group out of California that's been doing it throughout the nation. But it wasn't a legislative statute that was passed; it was a ballot initiative. And at the time, the group that was supporting it at the time, they were supporting it, get it on the ballot, and any time they're questioned, they repeatedly said, "This doesn't affect employers. It doesn't affect employers. They can have whatever policies they want. It's only intended to allow the use of medical marijuana by those who need it." So there was that, the public explanation for it as well, which I think played on in some of the court's mind as well, that there was no intent of the statute to actually require employers to modify their policies in any way. It was just to allow this option for someone who wants the medical marijuana to be able to get it. So essentially, you have to kind of make the choice. If you want to use it, you can, but you have to be careful about what your workplace policies are. The other holding in it, and the other argument was a public policy claim, which those are hard to get anyway, but essentially the plaintiff's attorneys argued that by enacting the ballot initiative, the electors of the state of Michigan essentially were saying, you know, we're fine with medical marijuana, and it shouldn't really private employers and public employers, for that matter, shouldn't be able to determine that we can't use it because you just said we could. But the court said no, it's just not we're not gonna go for that because, again, there's all the other statutes. It could have actually specifically said in Michigan, you know, this will count. But there's, you know, Michigan's an at-will state, generally speaking, unless you have a collective bargaining agreement. But it's an at-will state, and they said nothing in the act itself, as drafted, changes that or changes the right of employers to keep their drug policies. So that's essentially what's good.
Does the ADA come into play here, or is that kind of null because ADA is a federal act and marijuana is illegal under federal law?
Yeah, I think at this point it's null. I haven't seen any case that would expand it on the ADA. ADA doesn't require you to accommodate it in any way. Because,
yeah,
again,
I would jump in. You know, I think that this case is pretty representative of the leanings of courts at the moment across the country. The courts that have dealt with the ADA issue have uniformly stated, and that's regardless of whether it's applying the federal ADA or even certain states that have passed medical marijuana, there have been claims brought under that state-specific ADA equivalent. And one would think if there was going to be any chance of success under an ADA theory, it's going to be under the state version where that state has already granted medical or, if not medical, recreational marijuana. And the courts, both state and federal, have been uniform in finding that employers do not have any duties. I mean, the real problem, though, is kind of where things are headed. You know, certainly public opinion has changed considerably over the years, and as such, that's what's led to a lot of these states. I've dealt with the delegate who introduced Maryland's, or my home state's, medical marijuana legislation. They told me that the reason why these states have done it is because the federal government has refused to act on it. He felt that there was a public outcry, whether that's everyone's opinion or not is to be debated perhaps, but at least from his perspective as the sponsor in Maryland, he felt that, and he's spoken with others in other states that have said, you know what, if the federal government's not going to do anything about this, then we as states, we're going to go ahead and move forward. And that really is still causing that problem because so much of this stuff is in a gray area. You've got the fed government keeping it as that Schedule I member. I mean, frankly, maybe the easiest thing and the thing that's most likely to happen under the federal government is simply drop it from a Schedule I to a Schedule II. And basically the primary difference between a Schedule I and a Schedule II is simply establishing that there is a medical use for it. That's the primary distinction basically between the Schedule I and the Schedule II drug. Now as medical science has continued to develop, although I think that it's safe to say that it's at least arguable, if not conclusive, that there are very few peer-reviewed medical studies that have shown the effectiveness of medical marijuana, and that therefore by if at such time, rather, where there's been an accepted medical use, a commonly accepted one, the easiest thing the federal government could do is just drop it from Schedule 1 to Schedule 2, and that's probably going to take care of the conflict between the feds and the states. But right now what you have is the federal government almost putting its head in the sand on the issue, because last August the Attorney General's office went ahead, or the Department of Justice rather, issued on August 29th new DOJ enforcement priorities when it comes to marijuana. And really what they're saying is we're not going to enforce it as to John or Jane Doe. We're going to prevent its distribution to minors, preventing it from going to criminal enterprises, gangs, cartels, and basically we're going to go after the big boys and girls. We're not going to worry about the common user. Well, they may think that that actually does something, but as the employment realm looks at it, it really continues to create a problem where you've got this federal and state distinction. But at least going back to your point, and as I mentioned kind of earlier, Mark, is that really the states that are looking at it from an ADA issue are really saying that there is no federal protectable right under the ADA. And then, again, those state courts that have interpreted their own state versions of the ADA are similarly following federal courts' rulings that really there is no protectable right under the ADA, and therefore employers have generally been free to perform whatever discriminate or whatever discipline that they want to go ahead and do.
The other state decisions that I've seen in this area have really kind of followed Cassius. Are there any other notable decisions out there that you wanted to mention with regard to the wrongful termination issue before we move on to the next slide?
No, I mean, I think we've got cases that are really examples in California. We've got Montana. We've got Washington. We've got Oregon. You know, some of these, Oregon, there's the Emerald Steel Fabricators case versus Bureau of Labor and Industry. You've got the Roe versus Teletech customer care case out of Washington, the Johnson versus Columbia Falls case out of Montana. But they're all kind of following the same lines. What I guess the concern is, you've got already the state legislatures that are starting to deviate from federal law. And the state legislatures are saying, you know what, due to public opinion here, we really find that there's more of a consensus, or at least a larger minority, if not majority, at this point, saying that there are commonly used reasons or uses for medical marijuana, so we're going to go ahead and pass this legislation. What you have right now are the courts interpreting these laws, and the courts are still maintaining a pretty conservative philosophy across the board. What I question is, as the legislative issues become more entrenched, and as there becomes more of a willingness for the general populace to agree that medical marijuana is fine, for lack of a better word, or even recreational marijuana in certain states, I do wonder whether you're going to find courts that are going to start loosening up their interpretations as well. And the way that I think that they might do that is under a public policy standpoint. I don't think that the courts are likely going to look at it from an ADA issue or some of the other laws, but I could see the courts adopting public policy arguments, which are oftentimes exceptions to the at-will document, or doctrine rather, where as a public policy the courts could sit back and say, you know what, the legislature thinks that this is an acceptable use. The public, by and large, thinks that medical marijuana is an acceptable use. Perhaps an employer that doesn't have some other sort of safety issue, whether it's DOT or other types of safety-sensitive equipment, whether you might start getting courts to say, you know what, we do find that there is a strong countervailing public policy argument that it's against public policy to discriminate or to discipline a person for otherwise following doctor's orders under a valid state law. And that's where I could see it going, perhaps not in the near term, but a little bit longer down the road.
Yeah, I think Chuck? But just to follow up on that, I think you're right, and I think that would be the way to do it. And I think you'll see that. I think that's more likely to happen in a state like California or potentially Colorado and Washington, where they've actually approved the recreational use as well, because that kind of destigmatizes the whole thing and get there. Michigan's still a little too conservative, I think, for that kind of thing. But I think you're right. I think as more states and more states get this, and then I anticipate you'll see more states adopting kind of the recreational use as well, and eventually I think you could see that as a public policy, similar to what they tried to argue in the Cassius case. He tried to argue that, well, by passing this, and it was passed by about 63% of the electorate when it passed in Michigan, well, by passing that, it evidenced a public policy determination by the voters of the states that we're all right with this, and it should be an exception to the at-will employment, and you shouldn't be able to fire somebody because they are using the medical marijuana as long as they're doing it in compliance with the requirements of the act.
All right, let's go ahead and move on to the next slide, and that is dealing with prescription drugs, alcohol, and marijuana. For a very long time, employers have been dealing with alcohol can cause impairment. There's a lot of prescription opioid medications that people take that can cause significant impairment. My question to both of you is, how is this different from marijuana? Should or can employers be monitoring these other substances? Does HIPAA privacy laws come into play here? Who'd like to jump in on this first? Not everyone at once.
Final Jeopardy music cue. Sure, I'll jump in. I think on this that employers generally should have pretty consistent policies. I mean, those states that do not have any sort of marijuana legislation approving its use, whether recreational or medical, certainly they're safe to just continue on with their no tolerance policies or whatever they might have. Even though for those states that have medical marijuana, if not recreational, they're generally, employers are going to be afforded additional protections probably. Unlike folks where there might be some concerns for ADA issues for prescription drugs or alcohol, because of the fact that marijuana is still that federal Schedule I drug, I think that employers can look at these three issues, I guess the holy trinity of the prescription alcohol and illicit drug world, and basically use prescription drugs and alcohol as the lowest common denominator. Those are the ones, frankly, you have to be the most concerned about because you don't have the backup federal protection that it's illegal. But generally speaking, I think that they can. Now, an employer's right, so to speak, to inquire is going to depend based upon the medical necessity for the job. I don't know. I'll be interested to hear what Chuck's opinion, if it's any different on HIPAA. I'm not overly concerned about HIPAA. I'm perhaps more concerned with the ADA and the inquiry, the right or lack thereof of inquiry post-offer. I think you're going to have to look at these issues in terms of is it consistent with job and business necessity to make any inquiries. It's certainly one thing if a person's going out and operating a motor vehicle with a commercial driver's license, DOT applies there. You've got other issues if a person's utilizing a forklift. You've got safety-sensitive issues there, or even just a loader for a DOT, perhaps, a packer. But on the other hand, on the ADA side, if the person is a clerical worker, someone that's working in an office, maybe not with safety-sensitive equipment, maybe the inquiry is going to be less so something that an employer could do.
Yeah, I tend to agree with everything you said. I mean, I think that you do have the common denominator of the prescription drugs and alcohol because they're not illegal per se. I mean, to abuse prescription drugs can be, but those are things you can do, and then it's a little harder, I guess, to get those to where, the marijuana is still a federal crime to use or possess. So I think it's a little easier to have laws that, or have rules that treat it a little differently. I don't know that you want to. It kind of depends on, again, I think you're right, what kind of field you're in. When you have federal restrictions on it, that makes it pretty easy. You treat them differently because you have to. But otherwise, it kind of depends on what the job requires, what it takes. I think that, you know, the HIPAA, I don't know so much about HIPAA, but certainly with ADA and FMLA, there are some more potential issues where they can be applicable to issues where you have an ongoing alcoholism problem or ongoing prescription drug problem that actually may be covered under the ADA, where use of medical marijuana or marijuana at all is not going to be, because like we already talked about, you know, it still violates federal law, so there hasn't been a case out there that says it's protected under the ADA where alcoholism can be, you know, and the abuse of prescription drugs, I think, can be as well. So you have to look at those those issues, and I think you can treat them separately, but I don't know if you want to. And again, I think it's going to be come down to, you know, how does it affect the employee and their job, and where it makes sense to distinguish between them, you can, I think, but where it doesn't, you can probably treat them all similar, especially if they have the same or similar impact on the work the employee is actually doing. You know, for us sitting behind a desk, you know. Go ahead, sir.
I'm sorry, I didn't mean to step on your toes there. But, you know, I agree. I think that generally speaking, you know, just looking at it at a base level, you know, ADA obviously limits an employer's right to inquire. You've got limited rights post-offer, of course, to do your medical inquiry, whether it's referring out everyone in that job classification for a physical, and, you know, inquiring as to the use of prescription drugs, et cetera. You know, I would, until things change and there is that lack of quote-unquote backup federal protection for those states with medical marijuana, I think you treat it, your policies pretty consistently right now. If you've got a good drug and alcohol policy, I probably wouldn't change it at the moment, even if you're in a state with medical marijuana, given those decisions that we've been seeing out of the courts thus far. So you would follow your policy the way that you normally would. If you have random testing, continue to do it. If you've got the you know, reasonable suspicion or the post-accident drug and alcohol tests that you implement, go ahead and do it. You know, then it's going to become an issue if there is the detection of marijuana. Given the success that employers have had in those courts across the country for disciplining based upon a positive test for marijuana, you know, I think that employers are pretty safe to continue with their policies as they have. You know, the problem is going to be where the courts, if they start changing their decisions and their rationale and they start allowing those public policy arguments, well, then you're going to have to start treating marijuana a little bit differently in terms of now if you get that positive test for medical marijuana really across the board, wherever you are, you're pretty safe to go ahead and discipline that person. You know, there are going to be some slight variations in state law. There are a couple of states that have kind of a duty to go ahead and rehabilitate after a failed drug test. I think those states, I think there are some protections, and again, you have to check the individual state laws, but Maine, Minnesota, Rhode Island, Iowa, and Vermont all have some sort of rehabilitative requirements after a failed drug test. I think that also includes Puerto Rico as well. But generally speaking, aside from those protections, you can go ahead and terminate. If they start developing case law with the public policy issues, then you might have to start modifying your policies.
What about post-offer pre-employment physicals? Are the rules any different there when it comes to if there's a positive test for medical marijuana, or is the same type of you know, rule coming into play?
I think except for those states perhaps that have the rehabilitative requirement, I'm not sure how they're going to address only a post-offer pre-employment. Generally speaking, though, I think most employers, if they detect the presence of marijuana in the system, that they're going to be able to go ahead and effectively do what they want to. You know, employers could take the angle, you know what, this person is working in an office environment, not working with customers directly. There are no safety risks here, or at least they are modest, if any. You know, perhaps there's not a legitimate business necessity to keep this person off unless they start exhibiting odd behavior or such. But obviously, those folks that have some sort of safety concern, whether it's on a construction site, a motor carrier, in a manufacturing facility, they're going to be pretty free to say, you know what, still a violation of federal law, and we're going to go ahead and we're going to refuse to hire you based upon the presence in the system, and we're going to go ahead and probably be upheld, at least the way the courts have been looking at it. And I think what we're going to see, hopefully, is that we're going to see the tests be able to establish some sort of impairment. When we can only hope with the medical marijuana to see whether the person's impaired. And at that point, there might be some changes because simply the presence in the system may not show impairment, but if the medical science catches up and they can actually establish a level of impairment at a specific time, then you might need to tweak policies at this point. But right now, just the mere presence of it in the system is going to be enough. So if a person goes to work on Monday after having smoked it on Saturday, he or she may not actually be impaired, but because it's present in the system, the court rulings are pretty favorable to employers to say you can go ahead and either refuse to hire or terminate.
Yeah. I ran into that here in Michigan. I was actually at the grocery store a couple months ago, and they're short on baggers. And so I was bagging my own groceries, and the cashier told us just out of the blue, she says, we can't hire anybody because we just went through and tried to hire a bunch of people, and they all failed their drug test. So it was kind of funny there because they're talking baggers at a grocery store, and I would assume most of them have some experience with marijuana anyway. But that was the position I took, and I think Bert makes a good point that there's some employers, if you're looking at the position somebody's in and says, look, it's an office position, especially if someone who has a medical marijuana card, it's office position, they're, especially if they say, if you have a conversation after they test positive or get indication like the Cassius said, he says, look, I don't do it before work, I don't do it at work, I do it after I get home, and then it's essentially the effects are worn off by the next day, so it doesn't affect my job performance, that kind of thing. You may be in a position where you say, okay, really it's not a big deal for us, so we're going to allow it. But, the general rule, I think, is that for employers is they tend to be more in the conservative side and say, I'm just going to get rid of everybody because when the one guy comes in and he's a little more riff-raff looking and I decide, well, I don't like the way he looks and I'm not going to let him do it, where the other clean-cut person that tested positive we let happen, then we get into those kind of potential discrimination problems and other things. So I think oftentimes as employers we just kind of say, it's easier just to say no to everybody and then we don't have to ever argue why we said no to one person and yes to somebody else.
All right, let's go ahead and move on to the next topic, and that is a pending case in the state of Colorado, which is Coates versus Dish Network. And this is a case that really challenges the thoughts around a zero-tolerance policy in a state where medical marijuana is legal. Which of you'd like to start on this one?
I can if you want. That's fine.
Go ahead.
So similarly, the Coates, it's kind of like the Cassius case, a little different. Coates was employed by Dish Network and tested positive for the medical marijuana. He had the license and was able to use it. Again, said he never used it on the premises and never the influence at work, but he was fired after tested positive under the violation of the drug policy. Essentially, he filed a claim under the state Civil Rights Act, and this is one that Bert referenced a few minutes ago, where it's actually, he says, under the state Civil Rights Act, the state Civil Rights Act says it prohibits an employer from discharging an employee for engaging in any lawful activity off the premises of the employer during non-work hours. Had a few exceptions, and that's what he said he did. He said, look, I have a medical marijuana card. Coates is a paraplegic. He was about, I think he's 34 or so now. Paraplegic, and he used the medical marijuana essentially to ease the pain of the complications from his injuries. And he said, look, the state of Colorado lets us, it says right here, you can't discipline me for something I do off during non-working hours that's lawful. And the court went through this analysis of, okay, what does lawful mean under the state Civil Rights Act? And does it just mean what's lawful under state law? Does it mean what's lawful under federal law? And it's one of these, it's a great case for a lawyer to read because they spend a few pages talking about what lawful actually means. And these are the kind of cases that people get annoyed at lawyers about because we have to spend 5 pages determining what the word lawful means. But the majority of the court essentially says, determines in the long run that lawful means lawful under federal and state law in this case, and because the federal law still prohibited the use of marijuana, that under reading the State Civil Rights Act to only have that exception for lawful activity, it's not lawful under federal law, so therefore it doesn't apply, the state law doesn't apply to his situation, and the company, it was Dish Network in this case, has the right to terminate his employment. There was a dissent to that case where the dissenting judge basically said, he spent another couple of pages talking about what lawful activity meant, and his position was lawful activity only meant under state law, that the state legislature really didn't have anything to do with federal law, making federal law anything else. So when they passed the statute, it should only pertain to state law anyway, and shouldn't even talk about what federal law is under the State Civil Rights Act. We should be talking about what state law is. In this case, the state law provided that he could use the medical marijuana. He used it outside of work. It fall directly into the language of it, and he should not have been terminated, what the dissent said. And this case is on appeal to the state Supreme Court. So we'll see what happens. There's another similar case where the state Supreme Court had decided, again, that the person could be terminated for medical marijuana. This case came up, and the court actually decided to hear it, and I believe they're consolidating with the other case and going to issue a decision on both. So there's quite a bit of speculation right now to see, okay, where's the state going to go? Are they going to, continue with the argument that we've had that's been pretty much by all the other courts that says, well, it's prohibited under federal law, so therefore we're not going to allow it? Or is Colorado going to be the first state that says, look, our state is, through the public policy of adopting the medical marijuana and as well as the recreational marijuana, it's clear that our state and our electors are stating that the public policy is that we should allow this, and that the private employers in the state cannot, all employers probably under the state, can't violate that civil rights statute.
Bert, your thoughts on this case?
I just got to echo what Chuck said there. I agree. That's a real question. Are they going to be the first ones to dip their toes in the cold waters and say, you know what, we're going to deviate from what the rest of the states and the districts and federal circuits have done thus far and find this exception? So I think it's just a stay tuned.
This is one of those cases where, being a non-lawyer and looking at this case, the arguments just make sense. It's especially given the fact that there's no way to tell under the current science if they are currently impaired under marijuana. And I think that's the problem here. A person could have used it over the weekend or a week ago or 2 weeks ago, and they're under the current science, they're still going to pop as positive. So I think that one of the problems here that Coates is emphasizing is that the science isn't where it needs to be with regard to the impairment.
And I wish the legislatures had all thought about that before they actually started enacting all these. Unfortunately, that's where they've kind of put us, is they've given us this morass and this area where the medical literature is, ambiguous at best, and the science is non-existent. And they've put employers in just a treacherous position where they can't detect impairments based upon the science, and therefore, what else can they do? Kind of a damned situation.
I've seen several questions pop up on the Q&A list regarding the issue of what are the levels of impairment, and the answer is it doesn't exist. That's the problem here. That's one of the big issues with this, is the science isn't there as far as coming up with a test for impairment. There isn't a breathalyzer for marijuana that tells you whether or not they're impaired. It just doesn't exist. So until the science catches up with that, it really does complicate this issue.
And that's the real problem too, Mark, in terms of, when you've got the federal or the Schedule I drug, this is not an FDA-approved drug. And therefore, you have no regulation. You've got folks that are taking, Acapulco Gold or Costa Rica Black or White Widow or any of these other things, different types and terms of marijuana, And as an aside, I'll sit back, it must be really nice to be an expert on antitrust law or patent law because you're reading learned treatises and law review articles. And, in preparation for these talks, I'm looking up things such as High Times and weedblog.com to get my information. But without having any sort of regulation here, you really can't control the level of THC. So when someone is taking a puff off of a joint or taking a brownie, you're just running into situations where you can't regulate the quantity and be able to determine with any kind of efficacy whether or not there's an impairment or not.
And a kind of unrelated note, because it's out of Texas, but I kind of brought this up earlier when we were talking, but there's a case right now in Texas where the 19-year-old kid made some marijuana brownies, and essentially he used THC oil in them, and said he used about 2.5 grams of THC oil to make the brownies, but he's facing, under Texas law right now, 10 years to life in prison because it's based on the weight of the brownies, which is 1.5 pounds of brownies apparently made with this. So again, even that, if you look at how strong that is, how strong is 2.5 grams versus a 1.5 pounds of brownies, it's hard to tell. And everybody, people react differently. Again, we talked earlier about the people that tend to be more heavy users. It's like alcoholics, I imagine, where the more you drink, the less impact it has each time you do it. And then again, with the different strains of marijuana, and he was growing it, there's some that's a lot stronger than others and has a different impact. And those things are just really hard to tell and do put employers in a really hard position to determine, it's impossible to determine, what level of impairment the person's at when they show up and test positive for marijuana.
I'll just jump on, it's just been interesting to watch the expansion of all this. When we all started hearing about medical marijuana from out west, those of us that are in the east at least, we're hearing it with respect to use of terminal illnesses and glaucoma. Those are the two that I remember going back from years that we'd see it. The expansion now is included such things as I've even seen it prescribed for soft tissue injuries or, anecdotally hearing jokes from folks, well, I've got a cold today, so I'm going to go get my medical marijuana card and head on down to the dispensary. And you've seen the physicians and the healthcare providers prescribing this for a whole lot of conditions that weren't originally thought of as being the quote-unquote medical marijuana-related conditions. And you've seen more and more users of it, and without the availability of really good medical science to support this, you just see more and more risk for employers as more and more employees are going to have these covered conditions.
Yeah, I've seen recently, people talk about giving it for anxiety or stress. In Michigan, I think they just officially made it through regulation, so people with post-traumatic stress disorder actually you're able to get a prescription for it for that use. And the other thing about it, and we touched on it earlier, is kind of the expansion from medical marijuana to recreational marijuana. I think that largely in Michigan, that was the intent anyway. Let's start the medical marijuana because it does present itself better when you look at somebody who's in great pain, somebody with cancer, somebody with terminal illness. It makes it's hard to say no to that kind of person for anything that would make them feel better or help take their pain. But I think it's also a way to get it in the statutes. And I think expressly admitted by the people in Michigan that they wanted to get something on the books and then see if they could get it from there. And still in Michigan, there's a lot of, almost every time there's an election, there's cities around here that are decriminalizing, in the city at least, for certain things. So I think it is an expansion to the recreational use. Also, there was a study in Michigan probably a year or two after the law had passed, and I think in the first 2 years that the law was in effect, one doctor prescribed 70% of the medical marijuana cards. So you knew who the guy was, and you just went to him, and it was essentially, there wasn't a real heavy, detailed medical consultation examination. It was basically you walked in and said, I got a really bad headache you can't get rid of, migraines or whatever the qualified under the act when it was originally passed, and you just pay them and get it. So that's another issue, at least in Michigan here, is it really for just medical purposes, or is it just a way to get around the fact that you can't use it for recreational purposes? Because again, I don't think that doctor turned anybody away. He just made it fit within the statute and just handed out the cards and collected whatever his fee was for the extensive examination that I believe lasted about 15 minutes.
All right, let's now jump into how this is impacting the world of workers' compensation. And there's a number of questions in this area, including, if an employee is injured while on marijuana, is that a compensable injury? Is medical marijuana allowed for treatment under workers' compensation? What accommodations are required in this area? What protections are available to employers? On to our next topic, which is, again, how this impacts workers' compensation. Let's start with, if an injury occurs while you're high on marijuana, is this a compensable injury? Bert?
Yeah, generally speaking, hate to take the lawyer way out of it, but it depends. And it's going to depend on what state you're in. Obviously, it's going to be less so of an issue if you're in a state that it does not allow medical or recreational marijuana, and if it does, well, then you got to look at your comp statutes. Generally speaking, the statutes, and I've given a couple of examples on this slide and the next slide of variety of states that have handled it. But generally speaking, the states are going to fall into one of two categories. You've got those states that say, hey, look, we're going to follow the federal schedules of drugs. And if it's a Schedule I drug and it's illegal, and you are on it, and that leads to a work-related injury, then it is not compensable. Then that's on one hand. On the other hand, you've got those states that don't look at the federal law, so to speak, but what they're going to do simply is, if it's been prescribed lawfully by a healthcare provider, then, and you're injured while having used that or being under the influence of that, then it is going to be a compensable, and that's going to go along to if someone is on, oxy at work, or, even, high dosage of ibuprofen or something that just may make you a little off, those are going to be compensable. So you've got those states that are following federal law, and that's not going to be compensable, and you've got those states that are saying as long as they've been prescribed by a healthcare provider and you're injured as a result of the impairment from that, you are going to be found to have compensable injury. The real issue here is causation, and that's the problem that employers and their insurers or their claims representatives and defense counsel are going to have with these things. Because let's go to those states that say if it's a Scheduled I drug and it's illegal, and if you are injured as a result of that, then we're going to find that it's not compensable. Well, how are you going to prove it? With the way that the medical science is right now, if you can't determine from a positive test that a person has been injured or is impaired at the time of that test or at the time of that injury, how can you possibly prove that that actually led to the injury? When you've got these issues where it's staying in the bloodstream or however you're analyzing it for 5 to 30 days, how are you possibly going to be able to determine that the person was actually impaired at the time this accident took place? I kind of refer to an alcohol example because it's from my own personal practice. It's a pretty good example. I had a guy one time that blew a had a blood alcohol level of a 0.33 and was driving at the time. Clearly not only well past intoxication, over triple what the state allowed at that time in terms of a DWI, but depending on the individual, that could actually lead to alcohol overdose and even death at that level. Nonetheless, when he was injured, he was driving, going through a green light. The problem was the trash truck that went through a red light and struck our hero who had the .33, leaving him with crippling injuries. While he shouldn't have been out on the road, while he blew a .33, while it's 3 times plus over the legal limit, he did nothing wrong. And therefore, his impairment had absolutely nothing to do with the actual injury itself. that was in an alcohol situation where you can actually do a test and you can perform a level of impairment and see whether or not somebody was likely to be doing something wrong, impaired judgment, whatever it might be. With the medical marijuana testing at this point, and the fact that you can only detect the presence in the system somewhere between 5 and 30 days after this was inhaled, swallowed, whatever it might be, that you can't determine a level of impairment at the time, good luck to those employers and or their insurance carriers trying to defend these, saying that a person was impaired actually at the time of the accident. So while you may show that the person had the presence in the system, it's going to be extremely difficult in the medical marijuana or even recreational marijuana context to show that that actually led to a work-related injury. And as they say in workers' comp here in Maryland, if stupidity were a defense, we'd win every case. But in those cases where a person was perhaps impaired, they're just going to plead dumb and say that they did something negligently or without thinking that had nothing to do with the impact of marijuana, that it was just a mistake, a careless error that led to an injury, and that's probably going to be enough to withstand a commission or a finding and go ahead and have a compensable injury because the employer is going to be pointing to a positive test that can easily be established to be perhaps 5 to 30 days old.
Chuck, your thoughts?
No, I agree. I think you covered pretty much all of it. In Michigan, the policies are not required to compensate for the medical marijuana. But yeah, the same problems. I mean, it's essentially in most states you wouldn't, but the causation issue presents a problem in the states that kind of have the policy that Bert just described.
Well, my background includes handling claims for over 20 years, and so I've seen this situation arise repeatedly. And just to follow up on what you both said, when this comes down to an interpretation by the courts, whether or not the impairment caused the injury, courts are very liberal with that application. And I've seen case after case where employees were legally drunk at the time of the accident, but the courts determined that the impairment, that intoxication, was not the proximate cause of the accident. So, it's a very tough issue to deal with.
And just to follow up, one thing I guess I should say is, I know in Michigan, there's kind of a preference to give employees benefits, in that situation, and comp because they're hurt, even in their course of employment. So it tends to be the ALJs here tend to be more liberal about that, and unemployment as well, that it takes a lot to really show that you're not qualified for it. It's a really heavy burden on the employers to establish that the employee is not qualified, and it's much easier for the employees to find grounds to claim that they are.
All right, now what about medical marijuana as a treatment option in workers' compensation? Bert?
And that's going to be statute-driven. And to the extent that it's not statute-driven, it's going to be open to interpretation from the courts, obviously. There are a number of states that have actually explicitly put something into their legislation, those that fortunately thought ahead. Unfortunately, a lot of states, Maryland, my home state being one of them, really didn't think ahead, at least in terms of the workers' comp context. So when you look at Colorado, for instance, that indicates that no insurer shall be required to pay for it, which is really interesting considering the fact that Colorado is one of the most liberal jurisdictions allowing medical marijuana and recreational marijuana. You've got Michigan statute, and we've got a few other states that talk about it as well. So those states that have indicated in their statute and addressed it, a number of them have said, you know what, we're willing to allow medical marijuana in general, but we really don't want insurers, or specifically workers' comp insurers, perhaps, go ahead and pay for that. So those are the states that have actually addressed it. The majority, if not the vast majority, though, frankly, went into the legislation without thinking about the associated risks in the employment, and specifically workers' compensation, and really didn't address it. And you've now got these issues pending before state courts or state administrative agencies where these types of claims are held, and they're basically making up the case law as they go along. We in Maryland went ahead and just recently got medical marijuana. It's in its infancy, and as Chuck pointed out earlier, it was kind of a slippery slope. It just got really slippery really fast. 2 sessions ago, they passed the initial law with respect to medical marijuana, and basically they were saying, you know what, we're going to do this really thoughtfully. We're going to sit back, we're going to put in a commission, we're going to limit it to a select group of teaching hospitals, we're going to commission a study, and we're really going to take our time. Well, lo and behold, 1 session later, medical marijuana, here we come, Maryland. We went ahead and just full bore. And it didn't take long before one of my clients comes back to me after this was implemented and provides me with a doctor's note where our hero employee goes to his doctor and says he wants medical marijuana. Now, it's really not clear why. It's allegedly for a work-related accident, but the doctor indicates in his note, I told him I'm not going to go ahead and prescribe him medical marijuana for this condition, to which point the employee said that he's going to go find a new doctor. And I think we're seeing this doctor shopping already happening. But these types of issues, because of the relative infancy of the problem, are just starting to get to the courts now. Interestingly, in New Mexico, there was a decision that came out on May 21st and basically said that we get it, federal law. The court was fairly critical of the employers and insurers attorney in that one, in the opinion, at least to the extent where the court pointed out, well, you didn't make some arguments with respect to the federal-state conflict and illegality issues. So because you didn't make those, we're just going to examine it under state law. And right now our state law says you can prescribe marijuana, and we can't find anything in our statute that says that it wouldn't be a compensable remedy under workers' compensation, because there's nothing to the contrary, and the doctor here is recommending we're going to go ahead and find that medical marijuana is a compensable remedy. So you are starting to see courts at the administrative agency level, but now they're starting to work their way through the appellate process, and you're getting to courts such as New Mexico's appellate courts that are saying that, yeah, in fact, medical marijuana is going to be. And obviously that creates a whole host of problems, because now you've got state courts telling either self-insured employers or employers with their insurance companies to go ahead and violate federal law. So you've got a New Mexico court saying, yep, under our state law, it's a compensable workers' comp remedy, so therefore, employer and insurer, you are obligated to provide something that, if you look at federal law, is still illegal. And, what's an employer and insurer inclined to do? I know some anecdotally have decided to go ahead and not fight the issue, one, because they don't want to make bad law, and they don't want these kinds of appellate decisions floating out there where they're going to be obligated to, and they don't want to make any publicity, so that people sit back and go, oh, wait a minute, I'm on workers' comp. I'm sitting at home watching Judge Judy, off of work collecting temporary total disability benefits, eating bonbons, having a good old time. But now not only can I get OxyContin, I can go out and get medical marijuana too. And, a lot of employers or insurers are really reluctant to litigate these things fully at times. So I know some of them, if it's not a widespread problem and it doesn't seem to be something that's going to cost them an awful lot of money, are going ahead and authorizing it.
All right, as our time is winding down here, there's one last thing we're going to dive into, and that's really what should employers do here? And this is a complicated issue because things are changing. And in particular, the question I want to pose to you is, what happens? Let's look down the road here. And in a couple of years, as President Obama is winding up his term in office, and when they start doing all the things that they do at the last minute, he decides to issue an executive order reclassifying marijuana from a Schedule II to a Schedule I. Because, looking at it, the federal law is conflicting with so many state laws, so the decision is made, well, let's reclassify that. What effect is that going to have on all these existing drug-free workplace programs? So where do you see this going in the future? Chuck?
Well, I think if that happens, then we reconvene for another seminar and talk about it. But I think it certainly modifies everything we said today and potentially changes it. I think it would present an opportunity for courts and maybe even require some courts to actually really look at it as not illegal anymore. So it does open up all the things we've talked about today, where where can you still have a drug-free, zero tolerance policy? And I think the answer would likely be no, unless you're still in those kind of safety-sensitive positions, the driving positions, forklifts, that kind of stuff. So I think it would certainly make it harder to have a workplace that's zero tolerance, and it certainly opens the door to claims under, such as Colorado, under the Colorado discrimination civil rights statutes, and all the things we've talked about, the coverage under workers' comp and all that, because again, I think the courts largely are still relying on the fact that it's illegal under federal law to kind of justify. It's kind of an easy fallback, I guess, position to just say, look, I don't even have to think real hard about this because it's still illegal under federal law, so we really don't have to make an incredibly hard decision. We can just kind of rely on the fact that it's still illegal under federal law, so therefore it really doesn't change much. So I think if it becomes, class 2, or it is a prescription drug and then becomes legal as a prescription drug, I think that you're going to have to reevaluate all that and essentially treat it like other prescription drugs.
Bert, your thoughts?
Yeah, I mean, right now, I sympathize with everybody on the phone. We've got 1,100 plus people right now watching a webinar looking for answers on this issue. And if there's nothing else, I hate to be the Weasley lawyer that sits back and says, stay tuned, we don't have a great answer for you. But to some extent, that's true. I think the first part of the answer is that right now, with the way the courts have been interpreting the ADA, the public policy issues and such, at least, absent this potential DISH decision out of Colorado, which still is only going to have limited impact at first, at least. Right now, you're pretty safe keeping your drug and alcohol policies intact as they are. I wouldn't treat medical marijuana any different than you have been, and I would just go ahead and make sure that your random testing and your post-accident testing or your reasonable suspicion testing is good, that it's articulated in a clear policy that's following DOT guidelines, whatever industry that you're in. But the key thing is to continue to monitor for your state developments, particularly with respect to workers' compensation issues, as these issues are now being addressed in New Mexico and these other states as well. You want to make sure if you've got a significant enough workers' comp problem that your insurance carriers or your claims representatives are following your protocols and following the state law at that point. In terms of your overall policies, we're really looking, as this case law is evolving out of Colorado and these other jurisdictions, to see whether or not there are going to have to be special exemptions or exceptions or carve-outs for medical marijuana in your policy. But right now, I think you're relatively safe keeping status quo in your drug and alcohol policies. And if you don't have one, so I think most of the people probably on the line do, you really want to start examining about implementing them, but continue to make sure that they evolve as well.
All right, we're just about out of time, and I've been asking some of the audience questions as we've gone along here, but I wanted to plug in a couple of other questions really quickly here. First of all, given the political nature of this, and we're talking about classifying this as a Schedule I versus a Schedule II and things like that, what do you think that there's the possibility that we could put the genie back in the bottle if a more conservative political administration were to come into Washington? Could we see this push back against the medical marijuana and a step up of enforcing current federal law, or is that ship already sailed and there's no going back? Bert?
I think the toothpaste is probably out of the tube at this point, to use yet another analogy here.
We were running them through, Mark.
Yes, exactly. I think at this point, with all the state laws, there's going to be very little that a federal administration can do, even if they step up enforcement of Jane and John Doe, contrary to the DOJ August 2013 memo. Even if they step up enforcement, yeah, a person might have enhanced criminal risk, perhaps, but in terms of those states, I don't see a sea change in terms of all of these different legislatures on a state level reversing course at this point. And unless the feds really came down and said that their laws preempt state law, I think it's going to be a tough sell. So I suspect that it's probably not going to change.
Yeah, I agree 100%. I think that, especially the way this has developed, I mean, essentially it was state by state by state, and then, making it more of a national issue. you know, the way it developed is kind of a grassroots campaign. You know, let's start at the state, let's get it done here, let's hit another state. And they've been quite effectively, I think, in a political manner, they've been pretty effective politically, you know, getting it in. Again, in Michigan, the original act, I think one of the judges described it as one of the worst acts he's ever seen, just because it was their goal was just to get it in, get something in, and then we can continue to work on, you know, opening up the laws and eventually hopefully get the recreational laws passed. So I think it's already, again, it is out of the bottle, it's moving forward, and I think if anything it's going to keep going. I mean, a federal you know, more conservative administration could take a harder line on it, but I don't think it's politically, I don't think it gets very far. I think that there's already kind of you know, a lot of people don't see it as a big deal or see it as equivalent of, you know, alcohol or something. You know, it's not a hard drug like some of the other ones that are still the class 1 drugs. And I think people are more open to say, you know, look, it's really not that big a deal. We shouldn't be investing the time and energy by the police, federal and state level, you know, busting people for just smoking pot. And I just think that there's especially in the younger generation, there's a lot of push that really it's not that big a deal. Let's just relax about it. And I think that you'll see it the other way. I don't anticipate it going back at all.
Chuck, we talked a lot about how this affects employers in different ways. Does it matter how big the employer is? Do these rules differ based on the size of the employer, or is that not relevant?
I don't believe it is, although some of the, and I haven't looked at the DOT regs, and I don't believe that many of those affect, I don't think it's by size. I think it's just if you're subject to those rules and regs or not. So I don't think this is like the, you know, FMLA or one of those federal statutes where you have to be a particular size employer. It's just, it is what it is. Bert, you can correct me if I'm wrong, but I don't believe that it matters. Any of what we've discussed today matters on the size of the employer.
I agree with you.
Okay.
All right, we are running out of time here. Bert and I will be logging in about 15 minutes to the Lex Talk chat line to continue these discussions and answer more of your questions on the Lex Talk chat forum. So we do invite you to join us there.
And Mark, if you don't mind me stepping on your toes, if I can share one story. I've probably already bored you with this before, but I would like to tell folks about my favorite medical marijuana workers' compensation claim. This will be a short one, but I think there's a good learning point at the end. It's involving a man named Brock Hopkins who filed a workers' compensation claim in Montana in 2007. See, Brock Hopkins was a worker at a place called Great Bear Adventures in Montana. Bear spelled B-E-A-R for those of you keeping track at home. And as a worker at Great Bear Adventures, he was a bear handler. As bear handlers are not often wont to do before going off and working around a day of handling grizzly bears, he decided to partake in some medical marijuana. So he went and smoked some marijuana, headed off to work and to handle grizzly bears, and as that is likely to occur, he was mauled by that grizzly bear. The Workers' Compensation Court found in 2012 or 2011 that his use of marijuana to kick off, quote unquote, a day of working around grizzly bears was ill-advised to say the least and mind-bogglingly stupid to say the most. There was no evidence presented showing his level of impairment. The Workers' Compensation Commission went on to show that grizzlies are in fact, quote unquote, equal opportunity maulers without regard to the use of marijuana consumption, and therefore Mr. Hopkins was awarded $65,000 in past medicals. So I guess, and one thing that if you walk away from today with being able to remember one thing is never smoke marijuana with a bear behind.
Hey, let me plug in one more really quick question here because they're going to let me ask a couple more. And that is there a difference here for private sector versus public sector employees? Bert? Chuck? Let's go, Chuck.
With the case law that I've seen, I don't think that I've really seen a distinction between the public and private sectors. You know, I think that the case law has been predominantly private sectors from that which I've reviewed around the country. But I think at this point, when you're looking at the ADA issues, when you're looking at DOT and the other federal guidance, and regulations that I'm not seeing much of a distinction there.
Yeah, and I think it largely, most of the cases that have reported are private, just because there aren't those other avenues on public, collective bargaining agreements, those kind of things that deal with it. But I haven't seen anything that would distinguish the rights of public versus private employers.
There was also a person that asked about what's going on in these surrounding states that are surrounding Colorado and Washington. Are they reconsidering their policies? And I'm going to take this one because during the RIMS conference that I mentioned earlier, I moderated a public entity risk management session, and this was a huge part of that discussion. And I will tell you that it's giving the people in those border states fits, because the amount of marijuana trafficking into those states has skyrocketed significantly. And even though in these states you are required to show that you're a resident of the state, under the Colorado law, non-residents can still purchase it just in smaller quantities. So these states are having huge issues on the law enforcement side with regard to additional marijuana arrest, impairments, things like that, especially around the college campuses and things like that. This has escalated up significantly. One other issue that came up during that discussion from the law enforcement side that I never would have thought of is the drug dogs in these states. The law enforcement officials in the state of Colorado are having to get new drug dogs because their existing drug dogs were trained to hit on marijuana. And so now if they take those drug dogs out to a concert at Red Rocks, those dogs are just spinning in a circle going crazy. So they've literally got to go out and train new drug dogs who will not hit on marijuana. So that's one of those unintended consequences that they didn't think of when they passed this law, is from a law enforcement side, it's really kind of changing the way they're doing business. All right, I think we are just about out of time. Bring us home.
Thank you so much. On behalf of LexisNexis, I would like to thank Mark and Chuck and Bert for an excellent program today. There was a ton of information, and we hope that our attendees found it helpful. We encourage you all to visit the survey and complete it for us so we can continue to bring you excellent programs that meet your needs. Thank you all, and have a great day.